Well, I just want to say right now, to get this anticipates probably a little bit later in the discussion, this idea of Creative Commons that Warren Schlesig has been part of starting up, which allows people to actually do, give away their rights, so to speak, ahead of time.
Are people familiar with what Creative Commons is?
Yes.
Does anyone not know what Creative Commons is? Oh, we got a lot. Okay. Well, Creative Commons is
This is for that one guy.
Yeah. It's been described as
Two people.
It's been described as an alternative to copyright. It actually is based on copyright law. It uses copyright law. And what you can do is, if you're an artist, you can opt out of certain of your rights under the Copyright Act. You can.
It's using contract law. Right?
Yes, exactly. It's using contract law. You can, in a sense, have a contract with the rest of the world. You can put a Creative Commons tag on your piece of work, whatever it be, a film. And you can establish which rights you're retaining and which rights you're giving away. So you can say anyone is free to use this, but they must attribute the work to me. Or they can say everyone's free to use this except for commercial purposes. If you use it for a commercial purpose, you have to come back to me and get permission. There's many different licenses, including now sample licenses.
Yeah, we actually wrote the sampling license for Creative Commons.
That's right.
That's right. But and it was a very interesting experience. I mentioned this last night, I think, too. To be kind of, it made me realize that I thought maybe I was more of a cynic, and I realized I'm actually an idealist. And I realized that when you're, as an idealist, and you're trying to put that way of thinking into legalese, it's an impossibly painful process. It's very difficult. But as much as I love what I think Creative Commons, the most powerful thing about Creative Commons is not the individual licenses at all. It's simply the notion that just the very existence of it, just that term, so many people know it. It's used on millions of websites now. It's attached to millions of pieces of work. What it's saying in this gigantic cumulative way is simply, we don't believe in the existing system, we want an alternative. That's the most powerful thing about it. My critique of it, though, is that it gives you all these a la carte choices. Yeah. I don't believe in all the options they have in Creative Commons. I don't agree with any of them except the one we wrote. Because I all think they give you too many options. Like, I don't think artists deserve all those different options. And this is the thing where I feel there's education that sometimes needs to happen with artists, that there's a lot of assumptions you internalize in your society, in your culture. I mean, we internalize a lot of ideas about that are inherent in capitalism and private property and the whole way our country runs that are kind of unquestioned sometimes. Like, I'll talk to artists who are kind of offended at some of my ideas about reusing. No, you can't tear off a little piece of my photograph and use it in your work. It's my damn picture. Like, you can't do that. And you have to kind of walk them through this sort of argument that, yes, the idea of copyright, we're not against it. That there could be a limit, like 14 years. Great, I wish we had that. That'd be terrific. The way copyright was written is that there's a larger good at stake, which is the evolution of culture, ideas, art, science, and technology that's more important than you as an individual just being able to control what happens to your work. And so I think that creative people need to have more of a sense of community and generosity about, yeah, I put my work out there, and my work is an entire whole thing. Yes, it is that thing, and yes, I'd like to make money off it. But if someone else wants to muck with it and do bits, take something with it and do something with it, whether I like it or not, I think is absolutely irrelevant. Your opinion doesn't matter, because I feel like that's part of the true bargain of being in a true public domain, right? That you give up some of it. And as I said last night, if you want total control of your work, keep it in your bedroom. Show it to your friends, show it to your mom and dad. But if you want to engage with the world, with your work, and disseminate your ideas, I think you automatically you give up. You need to be okay with giving up. This idea of omnipotent control, and all this litigiousness we have, and the whole way we practice what I've heard called a kind of hyper-capitalism in this country. Perhaps there's a form of benevolent capitalism, but we sure as hell don't know how to do it. And so it's like we internalize, I think sometimes an artist can have like a little corporate lawyer and stuck in his head that he doesn't realize is there. You need to dig deeper into those issues.
Is that little voice charging by the hour? I didn't want to just be us up here talking ahead, so I did want to open up like a few questions. Yeah, all right.
I could wait for you to keep talking if you have more to say.
Please.
So one of the pieces that I thought was, I don't think I heard you mention it in the introduction to copyright copyright is this idea that it happens. Should I stand up?
Yeah,
It
speak
happens
louder, please.
Copyright happens automatically, and it didn't used to. So you had to choose to get your 14 years, and now you don't. And I'm wondering, especially if the artists here feel as though you wouldn't choose it at all if you could decide not to, or what you think about the way that messes with your ability to use works now.
Yeah, I wouldn't. You know, this right here, these notes, my notes that I've taken are actually copyrighted. And if you use them, I can sue you. And I think it's preposterous that there's this automatic privatization, you know, that Mark was actually talking about. So I don't know if I really can't speak to copyright law. I generally avoid it. You know what I mean? So, but I wouldn't choose to have that automatically in effect.
Well, there's another interesting idea that I believe Larry Lessig, who started Creative Commons, has put forth, which I think is a very simple, very brilliant idea. And there's talking about what are called orphaned works. That in fact, the largest number of pieces of intellectual property that exist in the world are all things that are made by people who are dead. No one cares, no one knows, but the laws still protect them in some sort of way. And he's made this interesting proposal. I think it's quite brilliant. It just says everyone needs to re-register their copyright on anything they care about every X number of years and pay $1.
Yeah.
And basically it's just saying, you know, if you care, if it even matters to you, then yes, make a little effort. But if it doesn't matter to you, or maybe it once mattered to you back in the 1950s, but it doesn't anymore because it's ancient history, you just can let it go. And he said that just that would free up this enormous body of work to then become all in the public domain.
Larry,
do you know more you know about this idea?
Yeah, well,
Yeah.
I do, but I
Did I
thought...
describe it right or no?
You did.
You
Okay,
did.
that's pretty good. And I'll talk a little bit about what problems there might be with that. But I thought I'd ask Larry just to explain, for those who don't know, you know, the automatic vesting of copyright in today and what the system used to be.
You know, the system, it's very interesting to, you know, think about how the system evolved. I don't pretend to know all the ins and outs, but we did have a system until '76 where you got your copyright for 28 years, and you had to renew it. And if you didn't renew it, it disappeared. And when this process I was describing before as the you know, the making of the sausage-like legislation in 1976, Congress heard a lot of testimony from artists who said, look, 28 years in an artistic life is, you know, you don't always make it within 28 years. There are people who, you know, they do work when they're young, and maybe they really, they're, you know, the little cliche about starving artists, you know, they're starving artists when they're in their 20s and maybe their 30s, and then sometime later on they start making money, and in essence, by that time they have families, they want to make more revenue. And I think there is, different art forms lend themselves to different career trajectories, but suffice to say, there are many art forms where you tend to get your revenue later on in your career rather than early in your career. So Congress heard a lot of testimony that the 28 years just isn't working real well, and they basically went to a system. And I think I'm right when I say the United States was not the first to do this, but I wouldn't swear to that. But in any case, the U.S. did go to a system in '78, which it was the lifetime of the artist plus, at the time, 50 years. And then there was, actually, the way we got to 70 years is interesting, which was an amendment in 1989 and 1990. The reason the U.S. went to the 70-year stretch at that point was because the European countries had gone to 70 years, and the United States, somewhat belatedly, was joining an international treaty called the Berne Convention. And Europe was already there, and our big trading partners were already there. So the U.S. Congress was getting pressure to go to 70 years at that time, and we did as part of, in essence, becoming more cooperative with the international community.